All right, good afternoon, everyone. Thank you all for coming. My name is Steve Dewey. I'm the director of the Washington, D.C. chapter of the Bastiat Society. The Bastiat Society is the public outreach program of the American Institute for Economic Research, otherwise known as AIER. The purpose of the Bastiat Society is to educate and promote the ideals of free market economics and sound money, property rights, personal liberty, and limited government. If you'd like to learn more about AIER and the Bastiat Society, our website address is aier.org. Today I'm very honored and excited to have two outstanding legal scholars, Adam White and Todd Zywicki, to speak on the recent Supreme Court decisions that have occurred on an important administrative law doctrine known as the Chevron Doctrine. This doctrine has been in place since 1984. With the Supreme Court decision on Chevron versus Natural Resources Defense Council. It was a case that gave deference to administrative agencies in interpreting and enforcing ambiguous statutes. However, just a couple of months ago, the Supreme Court decided two cases that overturned the Chevron Doctrine, the Loper Bright Enterprises case and the Relentless Inc. case. Both were lawsuits against the federal government. So with these two recent Supreme Court cases, what do they mean for the future of the administrative state and our liberties as Americans? Our two legal experts are about to tell us. I've asked Adam White to provide an overview of the administrative state, a brief history of how it started, how it has grown in scope and power in recent decades, and a brief explanation of the 1984 Chevron case. I've asked Todd Zywicki to explain the two recent Supreme Court decisions on the Loper Bright Enterprises case and the Relentless case and how they effectively overturned Chevron Doctrine and what it will mean for the American regulatory state and American economic freedom and personal liberty. A brief summary of our speakers' backgrounds. Adam White is the executive director of the C. Boyden Gray Center for the Study of the Administrative State at the Antonin Scalia Law School at George Mason University and a resident scholar at the American Enterprise Institute. He is also a public member of the Administrative Conference of the United States and has served on the leadership councils for the administrative law sections of both the American Bar Association and the Federalist Society. After clerking for Judge David Santil of the U.S. Court of Appeals for the D.C. Circuit, he practiced constitutional and regulatory law in Washington. He has served as executive director of the C. Boyden Gray Center since 2017. Adam White received his JD degree from Harvard Law School and his BBA degree in economics from University of Iowa. Todd Zywicki is the George Mason University Foundation Professor of Law at the Antonin Scalia Law School and at George Mason University. He's also research fellow at the Law and Economics Center and a former executive director of the Law and Economics Center at George Mason University. In 2020 to 2021, he served as the chair of the Consumer Financial Protection Bureau Task Force on Federal Consumer Financial Law. In 2019, he served as chair of the Association of American Law Schools section on law and economics. Professor Zywicki served as co-editor and editor of the Supreme Court Economic Review from 2001 up to 2017. In 2003 to 2004, he served as the director of the Office of Policy Planning at the Federal Trade Commission. He has taught at several law schools, including Vanderbilt University, Georgetown University Law Center, Boston College Law School, Mississippi College School of Law, and the China University of Political Science and Law. Professor Zywicki received his JD degree from University of Virginia, his MA degree in economics from Clemson University, and his AB degree from Dartmouth College. Each of our speakers will speak for roughly about 25 minutes for a total of 50 minutes. This will leave us with roughly about 10 minutes for our speakers to answer questions from attendees. So now we'll start off our discussion with Adam White, followed by Todd Zywicki. Adam, over to you.
Thanks, everybody. Who doesn't love a midday conversation about the administrative state? I hope they serve coffee at this. I have to admit, about whenever I'm introduced as being executive director of the Center for the Study of the Administrative State, there's always about a 50% chance that I'm misintroduced as running the Center for the Administrative State. Just to be clear here, that's actually at Georgetown across the river. So as Steve mentioned, I'm going to say a few words about the history of the administrative state, just setting the stage for where we are, because we really are at a pivotal generational turning point in the history of administrative law and constitutional self-government. And Todd will talk about where we might be headed next, and both of us will say a few words about where we are, including the most recent Supreme Court decisions. But first, let me give you a little bit of background on what we got, or how we got to this point. And you hear that term thrown around a lot, the administrative state. It's interesting. The center that I lead was founded in 2015 by then professor, then now Judge Naomi Rao. She's on the DC Circuit. And when she picked that name, the Center for the Study of the Administrative State, it wasn't, I'll put it this way, the administrative state is an old term. It's been thrown around at least since the 1950s, if not earlier. Some people have meant it as a compliment. I don't think Naomi did. And since the founding of the center, I've seen more and more progressives criticize the use of the term, the administrative state, which I tend to think of as a sign of intellectual success. The fact that we've pointed more folks to the downsides of the modern administrative state. When I use the term administrative state, what do I mean? Well, I mean a couple of things. Sometimes it just means looking out the window in Washington, D.C. and counting the number of government agencies. But what I mean when I use the term is something a bit different, and I'm borrowing this use of the term from Matthew Spalding. Some of you may know him from Hillsdale College. Matt once pointed out to me that the administrative state, the best way to understand the term is as a sensibility of government. The administrative state is a government in which administrative agencies are the center of gravity in government, that they're the major engine in policy making, that they're the center of our politics. I think that's how best to understand the term, the administrative state, and I think it's how best to understand our current political situation. We're just a few months away from a presidential election, and it's now become so familiar we don't notice how strange it is that a presidential election is kind of an everything election. We assume that every policy is kind of up for grabs in the presidency, not because the president will necessarily make legislation, but because we assume that presidents today have enormous discretion and latitude to make serious policy changes on just about any policy under the sun. We also expect that the presidential election is the centerpiece of the future of our judiciary. One thing that was left out of my bio is I served on the Presidential Commission to study the Supreme Court of the United States. There are some who want to change Supreme Court appointments, to make every Supreme Court seat expire after 18 years so that every president gets to appoint 2 justices per term. We kind of assume that Supreme Court justices are just downstream of presidential elections. Again, it's so familiar now, we take it for granted. But I think it would be extremely strange to anybody who was around 200 years ago, and hopefully it'll be strange to anybody who's around 200 years from now. But how did we get to this point with the modern administrative state being the center of our government? Sometimes people say, well, the problem is Congress delegates away too much power. Sometimes they say Congress writes laws that are too vague. And that's all true, but we shouldn't overstate that problem. There's always been what we would now call delegations of power by Congress to the executive branch. There's always been vague laws. And if you spend much time reading the Federalist, you'll see Hamilton and Madison anticipating exactly this question. In terms of the question about vagueness in laws, Madison warned us from the very start in Federalist 37 that you'll always have some vagueness in laws. It's impossible not to. He said, no matter how much time a subject is studied, no matter how much care and deliberation it goes into the writing of laws, you're always going to have some vagueness in the law that's going to have to be worked out over time. And by the same token, you're always going to have some kinds of delegation of power by Congress to the president. It's been there from the very start. It's been there since the Washington administration and the first Congress. And again, you see it in the Federalist. Hamilton seeing this in advance and arguing for a structure of a presidency where that kind of power could be used responsibly. If presidents weren't going to be delegated significant power, we wouldn't care if they had a long term or not, 4 years or not. We wouldn't care if they could be reelected or not. If they were just glorified clerks, that wouldn't really matter. From the start, we've always known that they would be delegated significant power, and we've always known that there'd be vagueness in the laws they were executing. But the way we got to the administrative state is because each of those problems became much, much worse. Because even if we can accept that there's going to be some delegations of power, even if we accept that laws are sometimes going to be vague, the challenge of Republican government is always to limit that as much as possible. But instead, what we've seen over 200 years is more and more delegations of power, more and more vagueness in law, and not by accident or just a concession to the difficulties of lawmaking. Rather, it became a feature instead of a bug. And I'm going to trace out that history very, very briefly. I'm from the Mississippi. I grew up alongside the Mississippi River in eastern Iowa. And so I always like to start the story with steamboats. The original executive agencies in their modern form, they were the steamboat commission. Steamboats were good at doing a couple of things: moving passengers, moving freight, and blowing up from time to time. First two things are good, not so much the third thing. And so one of the original modern regulatory agencies was the steamboat regulators, eventually a steamboat commission in the 1850s. But it's very different from what we have now today. You had a set of inspectors who would inspect steamboats, even set regulations for the inspection of steamboats. They had a lot of discretion, but it was very, very limited in their scope and their power. Unlike the CFPB, they didn't immediately try to regulate everything under the sun. They just stuck to steamboats and steamboat safety. The first major modern independent regulatory commission that a lot of people look to as the origins of the modern administrative state was the Interstate Commerce Commission. It no longer exists, but it was created in the 1880s to regulate railroads, interstate railroads. And what's interesting in hindsight is, while today we think of administrative agencies, the administrative state, as kind of pushing Congress out of a job, the Interstate Commerce Commission and other things like it were originally efforts to limit the courts. Concerns that juries and judges had too much power over railroads. You need this commission to have a body of experts that would be a substitute for the courts in certain ways. That was the original theory, at least. And frankly, for the first 200 years, for better and for worse, that was how you could understand the ICC, was replacing courts. But over decades, as the ICC got more and more into the lawmaking business, and other agencies like the Federal Trade Commission got into the lawmaking business, we came to understand these independent agencies, these multi-member commissions, as a substitute not just for courts, but for legislatures, for writing laws, because we thought Congress can't really write laws anymore. And the real architect of that, the intellectual architect, was Woodrow Wilson, and that first generation of progressive scholars in the early 20th century who wrote that Congress was not necessarily broken, but it never really worked in the first place, or it couldn't work for a modern government or a modern democracy where technology moved quickly, legal issues changed quickly. For those things, the argument went, we needed an agency-centric government that could make and change and enforce laws very, very quickly. Wilson, before he was president, was making these arguments as an academic. But there were plenty of people in government and in the intellectual world in DC and beyond who believed this, that we couldn't actually govern ourselves through a legislature. We needed agencies. And the reason why I bring this up is even that early argument for agencies in their modern form, it wasn't really about presidents. It was about regulators. The connection between presidents and the administrative state comes a little bit later with FDR. By the time Roosevelt becomes president in the midst of the Great Depression, you have this entire catalog of independent agencies, executive branch agencies, all doing more and more, making rules, changing rules, enforcing things. FDR's contribution to that change was, first of all, to turbocharge it, to urge Congress to delegate even more power to administrative agencies, and then to put the president firmly in charge of all of those agencies. One of the early constitutional cases on this issue about independent agencies, it was called Humphrey's Executor. It was an argument over whether the president could fire members of the FTC. That was the moment where you saw a growing administrative state collide with presidential power and an effort to subsume those agencies within presidential power. And I'll get back to that in just a moment. Because even from the New Deal era onward, for nearly 50 years, you saw the growth and spread of administrative agencies, not necessarily as a tool of presidential power, but as a tool of regulatory power in lieu of Congress. You saw agencies making more and more regulations. You saw Congress delegating power not just to regulate one agency regulating a particular industry, right, like the railroads, or you create the National Labor Relations Board to deal with union issues. But beginning especially in the 1960s, you see Congress passing laws that cut across all agencies. I think the environmental statutes are maybe the best example. The Clean Water Act, later the Clean Air Act, where Congress is just delegating broad powers to agencies, especially executive agencies, to make rules for a better, for a better environment or whatever the particular subject of the statute was, but sort of government-wide. So there, after the 1950s, you really see the agencies take over from Congress. Congress hands them enormous power, and the agencies say, okay, we've got this from here. We will make the rules from now on. In hindsight, the real turning point in all of this was probably the 1946. It's after Roosevelt dies, Truman's in office, and Congress passes a number of statutes that basically change Congress itself to go from being a lawmaking body to an oversight body. They passed the Congressional Reorganization Act, which is explicitly intended to reorient Congress around oversight. A year later, they passed the National Security Act, which formalizes the executive branch's control of national security issues. And also in 1946, the statute that we administrative law nerds learn inside and out, the Administrative Procedure Act, where Congress said, okay, agencies, you've been delegated all of this power. Here's the procedures we want you to use in carrying out that power, but the power is yours. So think of 1946 as the moment where Congress really makes official the fact that it's going to be first and foremost an oversight body. So will the courts, they'll be an oversight body, and the agencies themselves will be the ones making the rules. So now we're getting closer to the Chevron decision. I promise I'm getting to it in like 2 minutes. Because the last part of this evolution, as Congress is receding as a lawmaking body and making itself an oversight body, as the president, as agencies are asserting themselves, as the presidents are asserting themselves, the last part of this is the courts. And in the 1960s, the courts were also asserting themselves. Obviously, especially in constitutional law, right? Courts announcing more and more constitutional rights, often very, very disconnected from the actual text of the Constitution. And at the same time that that's happening, in the lower courts, in the DC Circuit especially, you have judges micromanaging agencies. You have judges, especially the ones appointed by Kennedy and Johnson and later Carter, over and over again, telling the Nixon and then Ford and eventually Reagan administrations that the agencies weren't regulating enough. So when Nixon, Ford, and then Reagan said, these agencies give us a lot of discretion and we're going to deregulate a little bit, you'd often have courts coming in and saying, no, you need to regulate more. One judge, she was later chief judge of the DC Circuit, she said, we considered ourselves the trustees of old Congresses. There to carry out not necessarily the words that Congress enacted, but the spirit that infused those Congresses. So by the time you get to the 1980s and that first generation of conservative judges, you have a wariness of regulatory, you have a wariness of overregulation, but you also have a wariness of judges micromanaging the president and presidential agencies. That's basically how you get Chevron deference. Beginning in the late 1970s and carrying to 1984 when Chevron was decided, you had the Supreme Court over and over again telling the lower courts, stop micromanaging agencies. They have a lot of discretion that's been given to them by Congress. And if they want to recalibrate regulation or deregulate, you can't be there constantly micromanaging them. Judges aren't policymakers. They're just there to interpret the law. And if the laws are vague, if they've delegated a lot of power, then the courts should defer to them. That's the Chevron case. The Chevron case in 1984 arose because the EPA rethought its approach to regulating air pollution. They created a new framework under the Clean Air Act that would make it, in some ways, easier for companies to comply without reducing the overall level of air pollution. Environmentalists sued to block the Reagan administration on this. That's why it's called Chevron versus Natural Resources Defense Council. The NRDC said courts should not defer. They should decide for themselves what's the right way to regulate, and they should impose that upon the EPA. The Rehnquist court under Chief Justice Rehnquist said, no, that's absolutely wrong. In this case, where the agency's been given a lot of discretion, we'll defer to the agency's reasonable interpretation of the law. And the greatest advocate for the Chevron doctrine, shortly after he joined the court, a little after the Chevron case was decided, was Antonin Scalia. He wrote a great article in 1989 in the Duke Law Journal, making an intellectual case for Chevron deference, saying judges aren't politicians, they're not policymakers, they're just here to read the law, and when the law is vague, they should treat it as a delegation of authority to the agencies. Scalia had a couple of caveats to that. He said, of course, I'm a textualist, so the first thing judges need to do is actually to read the law, and when the law is clear, you need to enforce it. And Scalia also warned in that article that sometimes agencies might flip-flop from one administration to the next. That's not a bad thing, at least not at first, but if the flip-flops get out of control, they get out of hand, well, that might raise some separate legal questions. But from the start, with those two caveats, Scalia said Chevron deference is not just okay, but he said it's a good thing. But those two caveats are the first things that fell away. Because while Scalia was a textualist, most judges at the time were not. And so you saw judges not even bother to read the laws before they would defer to agencies. Second, Scalia warned that flip-flops could be a problem if they got out of hand. Spoiler alert, that's exactly what happened. And 40 years after Chevron was decided, we now live, as I said at the outset, we live in a political system where we just assume that every law is basically up for grabs in every presidential election. And every 4 or 8 years, you'll get enormous swings in policy from a Republican administration to a Democratic administration, back and forth again. And that really there is the origins of the end of Chevron deference. I wrote a piece recently for Commentary Magazine that said, somebody asked, what's the Loper-Bright decision mean? What should we expect to happen? I said, it's too soon to tell. It took us 40 years to figure out what was actually in Chevron deference. And it's going to take us months, years, hopefully not decades, but definitely years to really understand what Loper-Bright did. Just a thumbnail sketch of the case really quickly. When this case arrives at the Supreme Court, it came out of a dispute out of the Commerce Department over fishing vessels. I'm always amused by the big administrative law cases. You get these huge sweeping constitutional decisions out of the most mundane settings, right? Which I think Shakespeare said, some men are born great, some have it thrust upon them. I mean, one of the biggest separation of powers cases the last 20 years, Loper-Bright, is a dispute over marine fishing vessels. The Commerce Department wanted to impose some new regulatory burdens and costs on these boats. Their owners sued. We get to the Supreme Court. And the Supreme Court says not only is Chevron a bad set of incentives, not only is it a bad way to think about government, it's affirmatively illegal. Chief Justice Roberts, writing for the majority, says that the Administrative Procedure Act requires the courts to decide what the law means. And any kind of framework for deference is totally at odds with that. The Chevron decision itself didn't even really read the APA, the Administrative Procedure Act. They just sort of left it to the side. And the Roberts Court said that was a mistake, that was a violation of the law. The courts have to decide for themselves what the law means. If Congress has delegated discretion to the agency, okay, the agency might have some room to make some policy-making judgments. But the court's fundamental obligation is to independently decide what the law means. That decision is very much an echo of the arguments made by Philip Hamburger and Randy Barnett, who for the last decade have argued that courts need to do more to assert themselves against the political branches. It also reflects the last 10 years worth of debate in the Supreme Court and in administrative law, worries that Chevron had gone overboard. And especially for the last decade, the leading advocate for this position on the Supreme Court was Clarence Thomas, who over and over again issued concurring opinions saying the courts have an obligation to say what the law is. Chevron deference flies in the face of it. Justice Gorsuch himself was also a strong advocate of that position. But I want to focus you just briefly on the justice who ended up writing the Loper-Bright decision, Chief Justice Roberts. Because for the last decade, he also has been very, very focused on this issue. That might come to as a surprise to court watchers who think of Chief Justice Roberts mostly in terms of upholding the Affordable Care Act's individual mandate, right? But if you look back at administrative law for the past 10 years, Chief Justice Roberts has been the most successful critic of the administrative state. He wouldn't go as far as Chief Justice Thomas would, but over and over again in majority opinions, Chief Justice Roberts on a number of issues would limit the agencies from flip-flopping from one side of a policy to another. This is one of the core features of Roberts' jurisprudence for the last decade, and you see it throughout this new Loper-Bright decision. Between the Roberts opinion and Gorsuch and Thomas, I think back to, once again, to Alexander Hamilton in the Federalist. He said over and over again that good constitutional government needs steady administration, not just energetic administration, but steady administration. And in many ways, I see the Roberts Court's decisions in Loper-Bright and other ways coming back to a steadier form of administrative law. Now, I will admit it's going to drive me crazy at times because, like I said, today government is a lot of flip-flops. I tend to like about 50% of them. I like the flips, just not the flops. But no matter where you stand on any given issue, when you watch it flip-flop from one presidential election to the next, just on the signature of an executive order, you realize it's really no way to run a country. So I'm curious to see what happens next. I'm turning over to Todd in just a moment, but here's what I'm watching for. Now that Chevron deference is gone and the courts have to independently say what the law means, textualist judges are going to have to work a lot harder to understand the meaning of laws. They can't just defer anymore. And so that's really going to push textualism in a new way. You'll see more disagreements among even conservative judges, but it's going to be very interesting to see what happens when judges look at a very broadly worded statute, any provision of the Clean Air Act, or let alone a provision of the Federal Communications Commission statute that says that radio licenses should be granted in the public interest. What does that mean? Courts are actually going to have to decide this. Second, I think as courts look at those statutes, judges will begin to throw up their hands and say there isn't actually any there. There isn't any real meaning in this statute, which is going to raise questions about whether, under the Constitution, that law should be struck down as a delegation of Congress's power. So those are the two big things I'm looking forward to. I have three other points that I'm going to leave. One, because I saw actually Todd writing down the same one. I'm not going to tell you which one it is until you talk. But a few other echo effects of Chevron. But here's how I would think about the administrative state. Big picture. I started with big picture. Let me end with big picture. In our system, we're supposed to have three branches of government. Congress looks forward and makes rules that are going to apply to all of us in the future. The president gets those rules and executes them, which is a mix of trying to understand what the law is, but it's also a lot of prudential considerations, how best to enforce the law in a given time and place. And then at the end of that process is the courts. The courts literally sit in judgment of what happened, right? They think about the facts, they decide the facts, they decide the law, but it's all looking backward, mostly looking backward. In the administrative state, everybody moves over one seat. Right? Because where are laws basically made now? Well, in the executive branch. A new president takes office, he signs some executive orders, his agencies make a bunch of rules. It all looks like legislation. It's slow, it takes time, and it's all looking to the future. What are the rules to govern in the future? Well, what happens next? The moment an executive order or law or regulation is made, somebody files a lawsuit. And the district courts, the Court of Appeals, the Supreme Court, very quickly are called into action. At the 200 years ago, the courts were slow. It took time for these things to go to the courts, let alone the Supreme Court. Now the courts are the most energetic part of our government. As soon as there's a new regulation, there's a district judge making a nationwide injunction. That's a little bit about the law, also a lot of prudential factors. Should we freeze that regulation or not? I don't want to overstate the analogy, but what I'm getting at is in the administrative state, it's the district judges who end up playing almost an executive role in deciding how laws are going to be enforced in a given moment in time. And that brings us to Congress. And if you're following me here, you know where I'm going with this. What does Congress mostly do? They're not looking forward, making rules. They're looking backward at what happened. They're mostly having oversight hearings where they kind of sit in judgment of everything. They actually, when you watch the oversight hearings, they look like a court. They're sitting, facing like a bunch of justices. There's witnesses. They ask questions. They criticize. But they are acting kind of like our Supreme Court of public opinion. They're really not doing anything looking forward. They're mostly just making judgments on what happened. So our executive is our legislature, our courts are our executive, and our legislature is our new courts. Now, that's all a function of all the policymaking power having been delegated over to the executive branch. At its best, what the Supreme Court is doing now is going to channel actual policymaking power back to Congress. If 10, 15, 20 years from now, Loeb Bright's a success, it'll be a success because it helped us get back to a place where lawmaking really begins with Congress. I'll turn it over to Todd.
Well, that was tour de force. What a treat to hear that. Adam is a exemplary administrative law scholar, professor, and I learn from him. I'm a public choice theorist who also studies the administrative state. Devin took my class a few years ago. And so I'm going to start off with a confession, which is this actually arose when I taught my public choice in the law class this past spring, which is I realized in the units we were talking about the administrative state, I kept involuntarily referring to administrative law. I kept, without even realizing it, I kept going administrative law. And I realized deep down inside, administrative law is an oxymoron, that there is no law there. I think it's a completely ridiculous sort of thing. I honor those like Adam who try to make it coherent. I listen to it and I listen to these deference doctrines, and there's Seminole Rock and there's this other one and these things and all the like. But in the end, I don't see any there. And I think from the beginning, the administrative law and the administrative state has largely been about politics and strategy. And so my takeaway from this is, yes, correcting Chevron was important, just to get the law right and to send a signal to the administrative state. However, I think it is just an opening salvo in what is going to need to be an ongoing trench warfare with the administrative state, especially the administrative state that is run by the left and by progressives, that is going to really test the tenacity of the court to do what needs to be done, and its fortitude in standing up to the kind of criticisms that it's already withstood, whether it was the EPA versus West Virginia case, these invocations of the major question doctrines and the like. And so this is not a silver bullet for reasons that I will say. And unfortunately, I already see an incoherence and a weakness in the Supreme Court's fortitude to actually tackle the true threat that the administrative state provides to freedom and prosperity and the rule of law. And we could start off by reminding ourselves that the concept of the rule of law, the modern concept of the rule of law, came to us by the British theorist A.V. Dicey, who was a judge in the late 19th century in Britain. And his book on the rule of law was written to do what? Deal with the early emergence of the administrative state. which is Dicey said the threat to the rule of law, which we've never had to really worry about before, is the modern administrative state, the way in which it acts, the way in which it combines legislative, executive, and others, and judicial functions, the way in which it's insulated from any constitutional oversight and the like. And so this tension between the administrative state and the rule of law has been there since the beginning. And when Hayek first dove into the administrative state, beginning with the road to serfdom and then really focusing on it in the Constitution of Liberty, when he moved from understanding that the threat to freedom was not economic central planning so much as it was first the rise of the administrative state and later the welfare state, the preoccupation of the Constitution of Liberty and the rule of law was on trying to tame the administrative state. So I will try to the best of my ability not to reflexively say administrative law, but now you'll know when I'm making scare quotes, it's because I mean it, and it is involuntary. So let's talk a little bit about the history and amplify a few things Adam said, because there's really nothing I can add substantively to that fascinating and insightful summary of the history, but I think it provides some backdrop to this. And in particular, what we see is how hoary old doctrines that might have made some sense in the context in which they originally rose basically got shanghaied and misdirected by Chevron. And why this is important is because it tells us something more about what's going on with the administrative state and the necessary role of judges and why the Supreme Court still doesn't get it in what's really going on with the administrative state and the importance of judges in policing the administrative state. So Adam mentioned, for example, the Administrative Procedure Act. Right nowadays, the Administrative Procedure Act is often seen as a deregulatory thing, a burden to regulation. But it's worth remembering, where did this flurry of lawmaking occur? Remember what Adam said? 1946. What happened in 1946? Yeah, that was part of it. But a little more anodyne was it looked like Truman was not going to be reelected president. And it looked like after FDR, after everything that was going on, the Republicans were going to finally, after being in the wilderness for a very long time, the Republicans were going to come on. So why then did Democrats jam through the Administrative Procedure Act? Not to block regulation, to block deregulation. They wanted to preserve everything that Roosevelt had done in this great flurry of regulation making during the New Deal, and they were afraid Republicans would come in and have their own flurry of deregulation. So what did? They put in all these sorts of things that Adam said, which was basically procedural obstacles, not to regulation, but to deregulation, to undoing the great rush of regulation and sort of, in many ways, sort of half-baked, sort of not thoroughly thought through sort of stuff that you saw during Roosevelt. So from the beginning, all of these efforts to so-called tame the administrative state were political. They were embedded in it. I'll say a second thing by way of background, in addition to being a public law guy, is I'm a bankruptcy. When I was at practice, I was in bankruptcy. Now, why is that interesting? The bankruptcy code, has anybody here ever experienced the bankruptcy code? It's a very, we'll put it artfully, poorly drafted statute. Congress has no expertise, and honestly, they don't care at all what's in the bankruptcy code. So it's a jumble of not well-designed provisions, we'll say. But what? There's no Chevron in bankruptcy. The judges just interpret the statute, right? They just sit down and they figure out what the bankruptcy code means. Judges can do this, right? It's possible to interpret statutes without being lazy and copying out like Chevron has allowed them to do. So as a bankruptcy person dealing with a complicated, somewhat convoluted and vague statute, the idea that somehow judges can't figure out what statutes mean just seems kind of absurd, because they do it all the time in bankruptcy. And I don't think there's anything unique about the bankruptcy code. So judges can do it. And I think to some extent, it's a matter of wanting to do it. So let's think about then where we get this path to Chevron. So let's think back then to the 1940s. Let's think back to this era that Adam was saying. Think about what that early regulation was. Adam referred to steamboats, steamships, the ICC. What was the original flurry of regulation under the during the initial progressive era? It's things like the Interstate Commerce Commission, electric utilities, airlines later, right? Are these the kind of things that the EPA and OSHA are doing later? No. What are they? They're basically public utility regulation, right? They're dealing with large natural monopolies, network industries, all these sorts of things, airlines, railroads, electrification, all this sort of stuff. So what was the kind of regulation the ICC did? They basically set rates. What was the type of regulation the Civil Aeronautics Board did? They set rates. What did the electric guys do? They set rates, right? Now, if you think about the task of the early regulatory agencies to set rates, right? What is a cost base, cost plus, that sort of thing. Do judges have anything to add to the question of how to set the proper rate, right? And so this was, what Adam was talking about. A lot of these early guys were basically there just to kind of get rid of state law on this sort of stuff, ambiguity about reasonable rates and, whatever those things might be, patchwork of different state laws, kind of preempt it, right? Deference makes sense in that context. And Roberts doesn't delve into it in the Loper-Bright decision, but he talks about early on, beginning in the 40s, beginning in the New Deal era and thereabouts, that's where you see this early doctrine that defers to factual decisions. So deference towards factual decisions, like what is the proper rate to set carriage of railroad cargo? It's like, yeah, that's vague, but Congress creates some standards. Nobody really cares in some fundamental sense, right? So you delegate that to basically green eye shade guys. That's not policy making, right? What was expertise? Expertise, again, was rate making. It's basically green eye shade stuff. A bunch of guys with slide rules figuring this stuff out, right? That's a lot different from the way in which expertise now has morphed into this kind of idiotic idea that we have now, that where they treat things like massive trade-offs between environmental goals and economic growth, or all these sorts of things as a matter of expertise, or the kind of crazy stuff that Fauci was doing, closing schools and stuff, right? As a follow the science stuff, right? But you see what the idea is they started with this fairly sensible idea of deference to facts, deference to rate setting, that sort of thing. And it gets expanded over time to this expertise and all this other sort of stuff, and fatally in Chevron, deference to law. Now, what we see in Chevron that's very interesting is what's the logic of Stevens' opinion? Why does the court abdicate there? There's this very interesting passage right in the middle of Chevron where Stevens says, we don't know why Congress left an ambiguity here. Maybe they didn't think about it, right? Maybe, maybe they just wanted to defer to the experts, right? Maybe, this is sort of modern public choice theory, maybe they couldn't forge an agreement on one side or the other, right? You've basically got two powerful interest groups on either side, and what we have is what they now refer to as a common thing in delegation, which is credit claiming, blame passing, where Congress will say, we're in favor of clean air, right? Well, somebody's got to pay for it, right? There's always trade-offs involved in that. So they punt it to the agency. The agency then has to decide which interest group, what's going to prevail, which interest group is going to bear the cost, how much, that sort of thing. And Congress then could claim credit for doing some of that clean air, but avoid the blame. And they say, oh, we didn't want you to, punish the oil business for this, or the dry cleaners, or the car makers, right? That's those crazy out of control bureaucrats, right? Which is even better for the politicians. Why? Because then they can get you coming and going. Because then you could complain to the politician, who then yells at the bureaucrat and say, we didn't tell you to make cars more expensive, right? You did that on your own, right? And then they can claim credit for that, right? Congress cannot claim credit for general solid oversight, right? That they have to personalize for electoral advantage, they need to basically personalize and claim credit for doing things. Just doing good oversight, writing good laws, doesn't help any particular congressman get elected in the modern age. And so the logic of, and so what Stevens says at the end of that passage is whether it was because Congress didn't think of it, Congress couldn't forge an agreement, Congress wanted to delegate, right? Whether Congress wanted to delegate for essentially a good reason or a political reason, the final word he said is for judicial purposes, it matters not which of these occurred. Stevens says it doesn't matter why Congress delegated. They just left a gap, and we're going to let the agency fill that in. Right now, underlying that is a particular model of politics, I would argue, and this is where now we start getting into sort of bigger pictures and why I think the court is clueless, because they're missing some fundamental lessons about the way in which the modern regulatory state does not cohere to the way they see the world. Underlying that model, we don't care why they delegated, is essentially the old Madisonian model, Federalist 51 of the Constitution. And Madison says, the way we're going to set up the Constitution, the interest of the man will be aligned with the constitutional rights of the place, which is to say, boiled down, which is essentially Congress will not over-delegate to the agencies because Congress will jealously protect its power. Congress will want the power to be able to write their own laws. Because that's what Congress does, right? And so they want their power. And so Congress as a body wants power, which means every single member of Congress will want to protect Congress's power. Well, it turns out that's an interesting theory. Sometimes it's true, but it turns out a lot of times it's not true, right? It is not the case that the interests of the man are aligned with the constitutional rights of the place in two ways, which is the first is, well, again, tip my hat to my our former colleague, Naomi Rao, now on the DC circuit. She drew a distinction between the collective Congress and individual members of Congress. So go back to the story I was just telling you about how delegation works. Doing good oversight, writing good laws, and constraining agencies is not something that an individual member of Congress can claim credit for. It takes a lot of effort to actually write a good law, to get an agreement on a good law. And all that stuff is just shared with all the other members of Congress. So what do you need? You need to be able to have identifiable things that you can take to interest groups and say, this is what I did. I got that regulation watered down to benefit you. I sent that letter on your behalf that I think can change the mind of these guys. So what happens is, especially if you're on a committee, what do you want to do? You want to have broad delegations, and then you want to be able to surgically intervene in very discrete ways to affect the details of legislation that then you could take back to interest groups and say, look what I did. You need to send me back to Congress, right? So, or you need to give me money. That's what I was saying, right? That's how you show that I get back to Congress, right? But you need to be able to claim credit for it, right? So it is not the case that the interest of the man, the interest of Congress as a body is to protect its power by not over-delegating. But it's not necessarily the interest of every member of Congress to protect Congress's power, right? So and we don't really have that problem in the agency branch, right? Everybody in the agency branch wants more power. We'll just put it, that's a crude generalization, right? They don't have that same sort of problem. Second problem is parties, which is that nowadays, the way in which the president is the vortex of all power and attention in Washington, parties come to dominate. So I'll give an example that really brought this to my life. There's an article by Levinson Pildes called Separation of Parties, Not Powers. Think back to the, you may remember a few years ago, the NLRB versus Noel Canning case. This was the case in which President Obama wanted to make recess appointments to the NLRB. The Republicans controlled, I think, one or both houses of Congress. They refused to allow Congress to recess specifically so that Obama could not make recess appointments. And in particular, what they were concerned about was Obama wanted to make a recess appointment of Richard Cordray to run the CFPB. Republicans were demanding structural change to the CFP before they would confirm a director. So Obama just declared them to be in recess. It's kind of absurd to think they even did this. The case is interesting. The case is interesting in the sense that it was a 9-0 repudiation of Obama in the case, including all the Democrats. But what was interesting to the case, to me, was Harry Reid and every single Democratic senator supported Obama. Think about that. Really, the only check Congress had over the CFPB, because they weren't allowed to review their budget, was confirmation of the director. And every single Democratic senator supported the president being able to declare Congress in recess so that he can make a recess appointment and thereby circumvent the no advice and consent provision, right? And if you see how bizarre that is, right, and how quickly James Madison must have been spinning in his grave, right, you see the extent to which parties drives a lot of this. In the self-interest of politicians in being reelected is signing on with the president and the president's agenda, even if that means, in this case, a huge gutting of congressional powers. So where does this, and so what does this all add up to? Which is that the Supreme Court needs to stop being so naive about the administrative state. In the way in which it's used, in the way in which Congress is going to take its responsibilities. And so I want to compare Loper-Bright, which I think is a step in the right direction, with Murphy versus Missouri and CFPB versus CFSA, which were decided the same terms, which are disastrous steps in the wrong direction. And why is this? Because while Loper-Bright is important to tame the formal powers of administrative agencies, they do nothing about the main way in which agencies act today, which is what Wayne Cruz of the Competitive Enterprise Institute, I like his phrase, he calls it regulatory dark matter. It is the guidances, the blog posts, the Dear Colleague letters, the speeches. It's all these ways in which the administrative state leans on private actors to do the things that they want to do. Now, the Supreme Court did a little bit about this in the NRA versus Vullo case. If you're familiar with this is a case out of New York where the New York banking examiner used a guidance document for insurance companies in the state to persuade them, to suggest, sorry, I can't say that with a straight face either, but to suggest to them that maybe they shouldn't provide insurance to gun groups like the NRA. Or specifically the NRA, that it would be a reputation risk for them to provide insurance policies to things like the NRA. And then she actually went to some of the insurance companies and said, I'll go easier on you on these regulatory problems you're having if you stop writing insurance policies for the NRA. I mean, it's just like almost surreal how heavy-handed this is, right? And this is a big deal because if you've been following the news, it's been an ongoing practice of Democratic administrations now to debank, to push for debanking of people and organizations that they don't like. So a bunch of religious liberties organizations, for example, have lost their bank accounts. Individuals have lost their bank accounts, right? And so why is this important? Because technically what that is a guidance, right? It's not, and it kind of not quite sure what that is, right? In some sense, it was, in a letter and all these sorts of things. Is that notice of comment rulemaking? Clearly not. We'll come back to this in a second and talk about, I think, an important case that deals with this, but it falls in this regulatory dark matter type thing, right? Conversations, that sort of thing. The court held an NRA that amounted to coercion that was essentially equivalent to a regulation to make it our way. But then on the other hand, you get Murphy versus Missouri, which was this appalling case, right? You're probably familiar with this, a social media case where the Obama or the Biden administration was yelling at social media companies to censor speech. They were not even making veiled threats. They were pretty unveiled threats that they might have to look at antitrust actions, repealing Section 230. Why are you guys killing people, right? A remarkable number of F-bombs communicating between the White House and these guys. And the Supreme Court decided that was not, there was nothing wrong with that. Right, that the social media companies didn't actually have to do anything, so this didn't amount to state action. That people couldn't trace for standing purposes what was going on here. And listening to the oral argument, it's just surreal to listen to how clueless the members of the Supreme Court are about how the administrative state actually works. Right? Anybody here who's lived in the real world, which apparently a lot of Supreme Court justices haven't, will understand that nowadays the administrative state doesn't just make suggestions to businesses, right? Especially this administration doesn't just make suggestions to businesses. Everybody understands there's a threat behind it. And so what are we going to get? There is a vast, vast range before you reach NRA versus VULO and the things that are covered by Loper-Bright versus the things that are Murphy versus Missouri. And the administrative state is like water. It's going to fill up, I would say, the cracks, but that is a reservoir of power, not just cracks in terms of how they will wield this power. And in fact, you may have just seen the FBI has announced they're going to start cooperating again with social media companies in a run-up to this fall's election. Let me talk about CFPB versus CFSA. This case was a challenge to the constitutionality of the fact that the CFPB doesn't have to be funded by appropriations from Congress, but instead draws its funds directly from the Fed. It was challenged as unconstitutional, violating the Appropriations Clause. A lot of details. 7-2, the Supreme Court rejected the argument. Thomas wrote the argument. All right. Why do I think that this is an important case? Because underlying the logic of Thomas's opinion, he's got this sort of, it's basically clause-based textualism, the opinion. But underlying it is essentially this old idea, this old and I think unrealistic idea of the Madisonian Constitution, which is Congress can always just take back its power. Well, Congress can't just take back the appropriations power, right? Why? Because the president can always veto it. And once you give power to the president, very few examples I could think of where Congress gave power to the president voluntarily gave it back by signing a law that says, okay, you're right, you can have your power back, right? It just doesn't work that way, right? It doesn't work that way in a party world, right? And so I think the court just missed the ball on this. Oh, and I should have said one last thing on Murphy, right? What Justice Alito said in his dissent there is, as long as the administrative state isn't as ham-fisted as they were in NRA versus VULO, the government's scot-free, right? So let me wrap this up and talk about where this goes, right? Why, Adam alluded to this, why did conservatives get enamored with Chevron in the first place? In the 60s, as he said, we had this judicial freelancing where judges were interpreting statutes broadly according to their overall purposes and basically running the country. The less bad alternative, I think, was Scalia's view, right? The lesser evil was administrative agencies. The choice between courts freelancing and administrative agencies basically doing things when they at least had some degree of democratic accountability. It'd be better to have agencies do it, right? I think what he thought was Congress will never let the agencies run wild, and the agencies themselves probably won't run wild. Both of those turned out to be wrong, right? Congress has not, as we said, shown no effort, desire to try to police them. And I think agencies have run wild before anybody's imagination, partly because courts have let them do it, because courts have been so deferential via Chevron that agencies can do these huge swings and make these completely implausible assertions of law and the like. And so now what we're getting is the backlash to try to tame the administrative state. Now, my concern, right? A very wise colleague of mine named Adam White once said to me, I know I'm not pro-Chevron, but I'm not sure whether I'm anti-Chevron or anti-Chevron. And I think the lesson of that is if you see what does the world post-Chevron look like? Well, if you read the King versus Burwell, the second Supreme Court case on Obamacare, what happens there? Roberts refuses to defer to the IRS on this taxing. And what does he then do? He engages in exactly the same sort of statutory freelancing, looking into the deep policy and making up policies, really, that are completely inconsistent with the statute with the language of the statute, in order to completely rewrite the statute and preserve Obamacare, basically, right? So that's the next challenge, right? The next challenge is, how do we keep courts now from getting back in the business if they don't have to defer to Chevron? How do we keep courts, especially these courts that are appointed that clearly have no, like the Biden appointees clearly have no respect for the rule of law? That's pretty obvious, right? How do we keep them from running roughshod again? Are we going to be back in a world where we've basically got judges running the country, where we've got judges, district judges issuing these nationwide injunctions and the like? And then what do we do about that? The second thing is what do we do about the fact that the administrative state operates through regulatory dark matter and can do more and more of it? And so long as the administrative state is in every nook and cranny of our lives and society, things like formal deference doctrines are not going to solve that problem, right? It's going to require more, and it's going to require an ongoing challenge of self-governance. And on that, I'm going to present the problem and sit down before someone asks me for a solution.
Okay, we have time for a couple of questions. See a few hands. So, Devin, go ahead, Devin.
I wrote an amicus brief earlier this year in Consumer Research v. Consumer Product Safety Commission, arguing that Humphrey's executor does not apply even to the modern FTC and any of these federal agencies because they execute executive power in rulemaking and in enforcement actions. I was wondering what your thoughts were on that. And then a couple other quick questions. How does Loper-Bright apply to adjudicatory agencies like the NLRB? And how does it apply to mixed questions of law and fact?
Well, maybe I'll start with that and the last two questions first. I take Loper-Bright to apply to anything an agency does, so it doesn't matter the vehicle. On your point about mixed law and fact, and Todd alluded to this, I do think one of the interesting things that'll come out of Loper-Bright is the courts will draw clearer lines between what's a question of law and what's a question of fact and what's a question of policy-making discretion. I think you'll see, by the way, future administrations, maybe a future Trump administration will try to push things into questions of law, while you'll see a Harris administration, for example, try to push things into contested questions of fact. But on your first question about the FTC, it's interesting. The Supreme Court a couple of years ago, they had a couple cases about independent agencies. And in one of them, the court drops a footnote. This was a Roberts opinion also, saying, Humphrey's executor said that agencies like the FTC could be independent because they are quasi-judicial, quasi-legislative. We're not going to revisit that question right now. Professor Daniel Crane of Michigan wrote a great piece, law review article a few years ago, and then one more recently he presented at a Gray Center roundtable, saying, as you say in your brief, that actually Humphrey's executor doesn't even apply to the modern FTC because the modern FTC isn't quasi-legislative, it's not quasi-judicial, it's just acting like a lawmaking, law-enforcing body. I think my favorite case to bring up that issue is actually a case involving Walmart. It's pending right now in the 7th Circuit in the District Court in Chicago. It was the FTC brings an enforcement action against Walmart. Walmart defends and says, hey, what do you think you're doing bringing an enforcement action against us? We've been told for 100 years, you're quasi-legislative, quasi-judicial. You can't have any enforcement power against us. That's executive branch stuff. We haven't seen the 7th Circuit do anything with it yet. But obviously the case it's the 5th Circuit, right? The Consumers Research case. This is on the Supreme Court review. It's on certain issues. Oh, it's on, where did it come out of? I think it might have been the 5th Circuit. Yeah, but so they're going to get to it first, but I think it's only a matter of time before the Supreme Court finally forces a rethinking of Humphrey's executor.
I would agree with that. One of the things that's interesting about this could be an area in which Thomas's dogged dissents eventually end up winning the day. And I just have to briefly say one interesting word about that, which is one of the things that's interesting about Thomas is, to the best of my knowledge, he's the only current member, that you could correct me, the only current member of the Supreme Court who actually served on an independent agency. All the others served the DOJ and that sort of thing. And Thomas served at the EEOC, right, which is, to put it bluntly, an especially buffoonish agency, staffed by buffoons for decades. Now, I'm not going to attribute that opinion to Thomas. I worked at the FTC. I worked at the CFPB. I don't know how anybody can work at an independent agency and think it bears any resemblance to what Kavanaugh and Roberts and these other guys think is going on in administrative agencies. They're not experts. They're political. Whatever they are, it's not what I think these guys think they are. And so it wouldn't surprise me if Thomas's skepticism of administrative agencies was to some extent informed by his actual experience working in an administrative agency that none of the other justices have had.
Yeah, we have to wrap things up at 1:30, so we have time for maybe one more question. Yes, in the back. We'll try to get in two more.
Okay.
Yeah.
Given the rise in coordination between government agencies, media, and the executive branch, is the evidentiary side of the state action doctrine likely to change?
Okay. Sure. Yeah.
Yes, good afternoon. For the first speaker, you indicated that you feel Congress does not legislate. It's more of a default judgment court. But, nowadays, I know it's political, but the line is that Biden has the most accomplished, actionable, administration in 100 years. I'm not saying I agree with that. It's more like pork barrel spending, which has gone from local to national. But my question is, so I feel like recently the only real policy making was Obamacare, but it's not getting recognized for that. And as far as the second speaker saying, it might be illegal. I mean, maybe the financing part, but you can liken it to Medicare or Medicaid. So that's my question. Why is something like Obamacare not being recognized as a major changing policy initiative?
Well, I'll just, to the second question first. It is true there has been major pieces of legislation like Obamacare, like the Dodd-Frank Act. But your other point, I think, is correct, that to the extent Congress is passing legislation, it's mostly passing spending legislation for which both the procedures and the incentives of Congress are completely different. Do you want to jump in, and then we'll get to the first question?
Yeah, real briefly. And what's important about Obamacare and Dodd-Frank, they were both passed essentially with 60 Democratic senators. They were passed during a period of filibuster-proof majority by shared government. I've got an article coming out at AIER. I did an op-ed earlier this summer talking about sort of Dodd-Frank as it relates to CFPB versus CFSA, and it's a good example of this idea of the way in which parties, to some extent, have overwhelmed separation of powers. It's precise that the problem with those cases is it's today's Congress tying the hands of future Congresses that can't be undone because of the filibuster, effectively.
Just really quick, do we have time? So to your question, sir, as Todd said, Wayne Cruz coined the term regulatory dark matter, which I think is really great, a great term. But to your point, I think we should think of this in terms of passive-aggressive administration. In the context that Todd pointed to, where the agency was telling social media companies to go do something, or when they tell the financial regulators or insurance companies to go do something, it reminds me a little bit of the joys of being an older brother. When I was a kid growing up, I had two younger brothers. And let me tell you, the greatest part about being an older brother is that moment where you pin your little brother down, you grab him by the hand, and you slap him with his own hand, and then say, "Stop slapping yourself." That's kind of the arguments around the Murphy case and the NRA case, where the government will over and over again and say, well, we didn't make anybody do anything. We didn't actually, I didn't slap him. He slapped himself. It's true in a way, but it's also deeply false. And I actually think one of the after effects, and I think actually Loper Bright will exacerbate this somewhat, because Chevron deference, for all of its faults, at least gave agencies an incentive to go through a rulemaking process. They'd get Chevron deference at the end of it. I think we're going to see, unfortunately now, more incentive for governments to do more and more through these passive-aggressive approaches, these kind of outsourcing of regulatory power. Years ago, before a lot of this blew up, back in 2017, I wrote a piece for a policy journal on the relationship between the Obama administration and the social media companies. And I called it Google.gov. And I was joking at the time, but these companies do have a lot of outsourced regulatory power that is not really going to be held accountable under old doctrines of judicial review.
And I'll add one footnote that there's a case coming up to the Fifth Circuit. It was already decided at the district court. It involves the CFPB basically trying to redefine the term unfairness to incorporate any racial disparities in the provision of financial services in any way, right? Disparate impact. They did it through changing one paragraph in their 200-page examination manual. The Chamber of Commerce challenged it, said that is effectively a rule. They need to go through notice of comment rulemaking. The district court said that's right. This is a rule. It can't just be done through guidance. It's going to go up to the Fifth Circuit, and I expect the Supreme Court. That, I think, is the next question, which is to what extent are courts going to actually try to police the use and abuse of this regulatory dark matter as an end run around formal regulatory processes, which are subject to notice of comment and rulemaking, and now not even Chevron deference necessarily.
Okay, that concludes our event, and I want to thank our two fantastic speakers. They did a great job. Thank you. Thank you all for coming.